The United States Supreme Court has just issued a major decision, a unanimous 9-0 ruling, in the case of Barnes v. Felix. This case directly involves the Fourth Amendment, which protects Americans against unconstitutional searches and seizures, and it raises an important question. When does the use of excessive force by law enforcement cross the line and become a violation of those rights? This ruling is significant for every American. It changes how courts must evaluate situations where police officers use force, and it reshapes how the law views the connection between a seizure under the Fourth Amendment and excessive force by officers. Now, this isn't a typical case involving a warrantless search or a traditional seizure like most people think of. Instead, the Supreme Court had to decide whether an officer's split-second use of deadly force during a confrontation counts as an unconstitutional seizure. Their unanimous decision now provides clear guidance on how these situations must be analyzed moving forward. For gun owners in particular, this decision has important implications. We've all seen highly publicized situations where law-abiding gun owners come into contact with law enforcement, sometimes during raids, mistaken identity cases, or chaotic encounters. In those moments, excessive force can lead to life-or-death consequences. The court's ruling here directly impacts how those kinds of incidents will be judged in the future, and how the Constitution protects individuals caught in those dangerous circumstances. This case eventually reached the United States Supreme Court. At the heart of the challenge was one key question. Should courts apply the moment of threat doctrine when evaluating excessive force claims under the Fourth Amendment, or should they apply a broader test? In a unanimous 9-0 decision, the Supreme Court held that claims involving excessive force by law enforcement during a stop or arrest must be evaluated under the Fourth Amendment. That means courts must determine whether the force used was objectively reasonable from the perspective of a reasonable officer on the scene. Importantly, the court emphasized that this evaluation requires looking at the totality of the circumstances, not just a split-second snapshot. Judges must carefully examine all the facts surrounding an incident, both leading up to it and during the encounter. This ruling firmly rejected the narrow moment of threat approach applied by the district court and upheld by the Fifth Circuit. Under that doctrine, courts only considered the officer's immediate danger in the exact moment force was used, ignoring the events before or after. The Supreme Court disagreed, explaining that limiting the analysis to just a few seconds overlooks critical context. Instead, lower courts are now directed to review the entire sequence of events, before, during, and in some cases even after the use of force, to determine whether it was constitutional. Some justices also wrote concurring opinions to add context. Justice Kavanaugh, joined by Justices Thomas, Barrett, and Alito, stressed the serious risks law enforcement officers face during traffic stops. They highlighted that these situations are among the most dangerous moments for officers and have tragically led to many fatalities. The concurrence made clear that courts must not dismiss the dangers officers encounter. However, they also cautioned that acknowledging those dangers does not mean giving officers blanket immunity. The totality of the circumstances must still be weighed fairly. In this case, the concurrence pointed out that when Barnes attempted to drive away, the officer had limited options. But the situation was made worse because the officer chose to jump onto the moving vehicle, putting himself in greater danger. The justices acknowledged that both the driver's actions and the officer's decisions contributed to how events unfolded. Another important point raised during oral arguments dealt with the intersection of excessive force and the Second Amendment right to self-defense. The court expressed concern about scenarios where law enforcement officers fail to properly identify themselves, such as during no-knock raids or situations where someone breaks into a home without clearly announcing they are police. In those circumstances, a resident might lawfully respond in self-defense, not realizing they are confronting an officer. Limiting review to only a moment of threat in such cases would effectively ignore whether the officer acted improperly leading up to the encounter. That could trample on a person's fundamental right to defend themselves, as well as their Second Amendment protections. While the court did not directly rule on this issue, the justices made it clear that it was a serious concern and one that must be considered when lower courts apply the totality of circumstances standard. The Supreme Court has now issued its mandate, sending this case back down to the lower courts. This does not mean that the Fifth Circuit or the District Court has automatically ruled in favor of Mr. Barnes's family. What it does mean is that those courts must now re-examine the case under the standard set by the Supreme Court, by looking at the totality of the circumstances before, during, and even after the incident, rather than applying the narrow moment of threat rule. There's also an unusual wrinkle in how this case is unfolding. The lawsuit is still being pursued by Mr. Barnes's mother and father. From what is publicly available, it appears his father is representing himself in part of the proceedings, filing pros motions from prison. He has asked the district court to reopen litigation in light of the Supreme Court's ruling. At the same time, the case is still with the Fifth Circuit, where a large number of filings are ongoing. The plaintiffs are also attempting to bring in additional defendants beyond just Officer Felix. These include the Department of Justice, which declined to take action against the officer, as well as local officials such as the mayor, other politicians, and members of the police department who were allegedly aware of the situation but took no steps to intervene. This expansion of the case could broaden its impact significantly. This is a major development. The Barnes v. Felix case has now been sent back for a new review, and the courts must reevaluate the officer's actions based on the totality of the circumstances. It will be important to see whether the lower courts now come to a different conclusion and potentially hold the officer accountable for excessive force. This decision is not only significant for the Barnes family, but also for the broader issue of how excessive force claims are handled across the country. The Supreme Court's rejection of the narrow moment of threat test could change the way courts evaluate many future cases involving law enforcement and the Fourth Amendment. I wanted to make you aware of this critical ruling and the ongoing proceedings. As this case develops further, I'll keep you updated here on the channel. If you'd like to support the channel and stay informed, one of the best ways to do that is by subscribing. As always, thank you for your time and your continued support.